My Lords, my Lady, in petition number E014 of 2024, by the third petitioner, the said allegation as to the constitutionality of standing order number 64 has been made, and still, my Lords, we do not have a provision of the Constitution which is alleged to have been violated. More importantly, my Lord, the third petitioner does not even make a prayer with regard to that particular allegation. But in petition number E509 of 2024, the petitioner therein alleges that standing order number 64, which provides for the impeachment process of the Deputy President, provides for a short period of 7 days to conduct
standing order number 54 or 64.
64, my Lord. Provides for only 7 days to conduct an impeachment, and therefore it violates the first petitioner's rights to fair hearing under Article 50. My Lord, we submit on that particular allegation that indeed the first petitioner was accorded all the rights by the National Assembly when they had the impeachment motion. But my Lord, notwithstanding the inadequacies of the allegation, that particular allegation in the petitions, we have attempted to address that particular allegation. And our submission is that the 7 to 12 day timeline under the Constitution, under the standing orders, does not violate the Constitution. And this, my Lord, stems from the Constitution itself, which sets the tone for hearing an impeachment motion against the Deputy President and the President. And the relevant article, my Lords, my Lady, is Article 145 of the Constitution, which has been referenced numerous times in these proceedings. And Article 145, my Lords and my Lady, the Speaker of the National Assembly must inform the Speaker of the Senate of the resolution to impeach a Deputy President. That's the Constitution. Article 145 also states that the Speaker of the Senate is required to convene a sitting within 7 days of receiving the same from the National Assembly. Article 145 also states that if the impeachment is by way of a special committee, the committee must investigate the matter and report within 10 days. The Senate must then take a vote within 10 days after receiving the report from the special committee. The requirement by the standing orders requiring between 7 to 12 days, my Lords and my Lady, merely mirrors the rhythm of Article 145 of the Constitution. To declare it unconstitutional would be tantamount to suggesting that the Constitution itself promotes unfair or impractical timelines. My Lords, where the Constitution itself contemplates a strict and temporal process such as the impeachment of a Deputy President, any subsidiary rules from the Constitution that advance that objective must be interpreted harmoniously with the Constitution. My Lord, the standing orders are enacted pursuant to Article 124 of the Constitution. As you have demonstrated, the Constitution contemplates that impeachment proceedings must be undertaken expeditiously. So when the standing orders provide for an expeditious manner in which an impeachment process ought to be undertaken, then they cannot surely be declared unconstitutional. And my Lord, we make reference to a decision of this honorable court in Baraka Isa Pombo versus the Independent Electoral and Boundaries Commission. The same decision appears at volume 2 of our digest of authorities, specifically page 714. In that case, this court held as follows. If timelines in determination of electoral dispute is a norm and principle of the Constitution, then all the rules that further such norms and principles are themselves derivatives of the constitutional ethos and must, as of necessity, be complied with to the letter. We have also referred this honorable court to another decision, which appears at page 729 of the same digest of authorities, that is volume 2. That is Biosystems Consultant versus Nearly Links Arcade. It's a 2023 decision where this court found that the constitutional timelines are cast in stone. The decisions over time have crystallized this. The matter is mainly, the Supreme Court and the Court of Appeal have dealt with the various constitutional timelines and for good measure found their inflexibility. So, my Lord, based on those authorities and our submissions, we pray that this honorable court finds against the petitioners in relation to the allegation that Standing Order number 64 of the National Assembly Standing Orders is unconstitutional. And my lords and my lady, just to contradistinguish with other instances in the Constitution, Article 105 of the Constitution provides that when there is an election petition stemming from an election of a member of parliament, such a petition must be heard and determined within 6 months from the date of filing. The Constitution does not provide for timelines for hearing of petitions from decisions from elections of members of the County Assembly. But when you look at Section 75 of the Elections Act, it provides, similar to the Constitution, that in elections relating to members of the County Assembly, courts must hear and determine those petitions within 6 months. So we cannot really argue that the Elections Act is unconstitutional, providing the same timeline as the Constitution, just because they now relate to members of the County Assembly and not to members of Parliament. My lords, now I'll proceed to the second issue as to whether the National Assembly was not properly constituted to hear and determine or approve the impeachment motion of the first petitioner for failure to adhere to the 2/3 gender rule under the Constitution. Our first submission on that particular point, my lord and my lady, is that we need to point out to this honorable court that this particular question is pending before a 5-judge bench of this court. In the case of Milimani High Court petition number E291 of 2020, Lena Conchella and another versus Honorable Justice David Kenani Maraga and others. There are several petitions which are being consolidated under that particular petition. My lord, this petition having been filed before the instant petitions, having been filed in 2020, it's a 2020 ongoing matter, this court ought to stay a decision on this matter on the basis that it is a matter which is sub judice. But my lords, without prejudice to that argument, we want to highlight some points before this court in the event this court goes on and makes a determination on this particular issue. The first, my lord, is our submission, it is our submission that the Parliament is actually properly constituted. And my Lord, we say so based on a reading of the Constitution. My Lord and my Lady, in relation to the question of the Constitution of Parliament, the same has been expressly stated in the Constitution. Article 97 states, in fact, it reads Part 2, Composition and Membership of Parliament. And then Article 97 states, Membership of the National Assembly. The National Assembly consists of, and it lists members of the National Assembly. 290 members, each elected by the registered voters in a single member constituencies, 47 women representatives, 12 members who are nominated by parliamentary political parties, and the Speaker, who is an ex-officio member. Once Parliament has fulfilled that mandate, my Lords and my Lady, we cannot then argue that Parliament has not been properly constituted. But my Lord, the question that begs is, what then is the position of Article 81B of the Constitution, which the petitioners have referred this court to? Article 81B states that not more than 2/3 of members of elective public bodies, including Parliament, shall be of the same gender. Article 27.8 then says that Parliament shall enact legislation to fulfill that requirement. It is common ground, my Lords and my Lady, that Parliament is yet to enact that particular legislation. But it is also a submission that failure to enact that legislation does not render Parliament to be properly constituted. And the reason we make this submission is based on a decision by the Supreme Court, which was provided before this Honorable Court in the second and seventh respondents supplementary list and band of authorities. My Lord, when confronted with this issue, the Supreme Court, in Advisory Opinion number 2 of 2012, which my Lord, I must say some of the members before the court were before the bench at the time, had this to say at paragraph 74, that as Article 81B of the Constitution, standing as a general principle, it cannot replace the specific provisions of Article 97 and 98 of the Constitution, not having ripened into specific enforceable rights as far as the composition of the National Assembly and the Senate are concerned. That is the Supreme Court. The Supreme Court, under paragraph 64 of the same decision, also states as follows. We are concerned by the fact that none of the Council who urged the immediate enforcement of the gender equity rule devoted their attention to the inherently different paths of enforcement for a specific accrued right on one hand and a broad protective principle on the other. It is clear to us that Article 81 of the Constitution bears the heading General Principles of the Electoral System. The Supreme Court, my Lord, went on to say that unless and until Parliament enacts legislation, it could not be expected to comply with Article 81 of the Constitution, but its composition will remain valid. But my Lord, even if the court was to find that the Parliament is not properly composed or constituted, it is our submission that the prayers made by the petitioners on this particular issue could not issue, because the Constitution itself guides the court as to the type of order it can make when it finds that Parliament has not been properly constituted. Under Article 261 of the Constitution, my Lord and my Lady, the Constitution says that when a petitioner approaches this Honorable Court seeking a declaration that Parliament has not been properly constituted, the court will make a declaratory order and shall direct Parliament to comply within a specified period of time. That is the order that this court can give. After issuing that order, and Parliament failing to comply with such an order, then, my lord and my lady, the next step is for the Chief Justice to advise the President to dissolve Parliament. The wording of Article 261 of the Constitution is very critical because it is forward-looking. The Constitution does not state that improper constitution of Parliament annuls the acts of Parliament going backwards. It is after the President has dissolved Parliament, upon advice by the Chief Justice, that we then get into a situation where all subsequent acts of Parliament will be deemed nullified until a new Parliament comes into place. And my lord, this is important because the first petitioner, having been impeached by the National Assembly and subsequently the impeachment having been upheld by the Senate, such an act cannot be reversed because the Constitution only contemplates dissolution of Parliament going forward. But equally importantly, my lords, it is our submission that when that act is done and a new Parliament comes into force, the provisions of Article 261 starts running afresh. In this particular matter, my lord, once the 13th Parliament was elected into office, we have not had an instance where this court has made an order declaring Parliament not to be properly constituted, and the same having been forwarded to Parliament, and Parliament failing to comply, and the Chief Justice advising the President, and the President dissolving Parliament. Those steps under Article 261 of the Constitution have not crystallized. On this basis, my lords and my lady, it is a humble submission that the petitioner's prayer, to the extent that they seek a finding that Parliament was not properly constituted at the time it is deliberated over and made a resolution to impeach the first petitioner, cannot issue. Unless the bench has questions for me, I thank you for this opportunity.
Thank you. My lady, my lords, my name is Rigathi, appearing for the National Assembly, and I shall be addressing you on the question of public participation before the National Assembly. I shall also briefly touch on the authorities which was submitted by my learned friend Mr. Sakimba and Mr. Kikamungai. To start with, Lord, I shall address you on public participation in three perspectives. The first perspective is the question of thresholds. The second perspective is how the National Assembly applied that constitutional value. And lastly, I shall address the various questions which have been raised by the various petitioners. And I think this is one issue which cuts through all the petitions, with the exception of the petition filed by my good friend Tess from Gachagua. My lords, my lady, the Constitution in Article 118 requires Parliament, and Parliament here is the two houses, the National Assembly and the Senate, to facilitate public participation in lawmaking and its processes. The key word used in that article, my lords, my lady, is facilitate. It imposes on Parliament to facilitate public participation and involvement of the public in undertaking its business and in its committees. That is important, my lord, because the manner in which the petitioners have couched their petitions before you is to create the impression that Parliament is compelled to ensure mass attendance by the members of the public to public participation forum, to obtain certain numerical numbers and such like. It is the responsibility of Parliament in Article 118 is to facilitate public participation. And this, my lord, was interpreted by the Supreme Court in Supreme Court petition number, it is, the correct citation is Cabinet Secretary for the National Treasury and Planning and 4 others versus Okoiti and 52 others. And at page 143 of that decision, the court said, Article 118.1 only imposes a duty to facilitate public participation and involvement in legislative processes, and therefore cannot be basis for the argument that the National Assembly is under an obligation to provide reasons or for accepting or rejecting views. And the same court quoted the South African decision in Mogale as the Speaker of the National Assembly, where the court defined what Parliament is required to ask itself. And it posed like this. What Parliament itself, the first rubric is A, what Parliament itself has determined is reasonable and how it has decided it will facilitate public involvement. B, the importance of the legislation or the process being undertaken and its impact on the public. And C, time constraints on the passage of the particular bill and the potential expense. Those are the key guiding factors which the Supreme Court identified when it cited the Mogale decision. Crucially, my lord, my lady, at paragraph 88 of the same decision, imposed an obligation on persons who are challenging public participation. And it found, my lord, my lady, that allegations of lack of public participation does not automatically vitiate the process. The allegations must be considered within the circumstances of each case, the mode, the degree, the scope, and the extent of public participation, and it is to be determined on a case-to-case basis. So, my lord, the responsibility of Parliament is to open the door. To open the door for citizens to engage in that particular, whichever undertaking Parliament may be dealing with. It is not to drag citizens through that door. Once Parliament has provided a platform, it is the civic duty of every citizen to utilize that opportunity and engage Parliament for purposes of these proceedings, the National Assembly. So that, my lord, it is immaterial the number of Kenyans who have submitted views on any particular subject. What is material is whether the National Assembly afforded a reasonable opportunity for every Kenyan to submit those views. That again was highlighted by the Supreme Court. So that, my lord, when my learned friend Mr. Tom Macharia, a very good friend, argues that 200,000 Kenyans submitted views and ascribes a percentage as against the entire population of this country, it's our submission, my lord, that he misses the point by a mile. The second aspect of principle which we wish to address you on, my lord, is a question as to why public participation? What is the import? What is the purpose of public participation? And I can do no more, my lord, than to agree with Senior Counsel Professor Rigathi when he made the case that the role of the public is to influence the process. They do not vote. They assist those who will vote to make the decision. In the particular case we are dealing with, my lords, my lady, and on an important vote such as impeachment of a deputy president, it is some sort of an instruction by the members of the public, those who elected the MPs, on what they think about that particular motion. But at the end of the day, it is the particular members of parliament who will take the decision on which direction to vote. And that is the character, the nature of representative democracy. That is the expectation and the anticipation of our constitution. The Supreme Court, in the same decision, at paragraph 84 of their decision, state, that the constitutional framework acknowledges that while complexities of a modern state require this decision-making by representatives, these processes must involve meaningful public participation to achieve democratic legitimacy. These two facets of our democracy should not be seen as conflicting with each other, but as complementary. And they proceed in paragraph 83. They cite the decision of the Court of Appeal in Evans' case. My lord, all those are in our authorities. I need not prejudge it before you. The third element, the third issue of principle which I wish to address you on, is that with respect to impeachment proceedings, these were time-bound proceedings. And public participation with respect to impeachment proceedings must be taken within the context of the time available to whichever organ of the legislative assemblies which is dealing with that matter. And any analysis on adequacy of public participation must be measured against the time available for the particular house as it rendered its determination. Again, the decision of the Supreme Court in Okoiti, it's popularly known as the Finance Bill decision, at paragraph 125, the Supreme Court states, timelines, whether statutory or constitutional, and the cost implications, the mode and the approach to public participation should be taken into account in deciding whether Parliament has complied with its duty to facilitate public participation. Therefore, where evidence is proffered demonstrating that Parliament was required to pass a bill within a specified period of time, this factor will be accorded weight in determining the reasonableness of the measures put in place to facilitate public participation. As I submit, my lord, my lady, impeachment proceedings are time-bound. The adequacy or otherwise of the public participation which was undertaken has to be measured against the time available for the National Assembly. Similar sentiments were expressed by the Supreme Court in paragraph 127 of that same decision. I shall now address you on how the National Assembly went about conducting public participation for purposes of the impeachment proceedings against the first petition. And I would start by saying the record speaks for itself. we submitted an affidavit which contains lengthy material, which was introduced, which demonstrating public participation undertaken by the National Assembly, and I will highlight a few of the channels which the National Assembly utilized to reach as many Kenyans as they could possibly do. Number one, my lords, my lady, notices were published in the mainstream dailies in both English and Kiswahili. And that was on 2nd, 3rd, and 4th of October 2024. I have to refer my lords to Annexure SN5, running on pages 225 to 234 of the affidavit of Samuel Njoroge. In the same affidavit, my lord, my lady, it's a fact that notices were broadcast on mainstream TV channels, radio stations, and on Parliament's official website, together with its social media handles, X, Facebook, TikTok, Instagram. Again, this is in Annexure SN7 of the affidavit of Samuel Njoroge. My lord, there were public hearings initially held at every county headquarters, where members of the public were invited to engage staff of the National Assembly and submit their views through templates which were provided to them. It's important, my lord, to point out that the grounds upon which the past respondent was to be impeached on was set out not only in those templates, but also in the publication I adverted to earlier. Again, my lord, my lady, those are attached. And then, my lord, there were public hearings on 4th and 5th of October 2024 in every county headquarters. There was an order issued by His Lordship Justice Mwongo in petition E014, and I believe it's one of the petitions you shall be determining, my lord. And the interlocutory order was issued directing the National Assembly to expand the scope of public participation to constituencies. And that was done, my lord. So effectively, my lord, public participation was also undertaken in all the 290 constituencies in the country. My lord, Parliament also provided a dedicated email address from which members of the public who are unable to submit their views physically could send their views to Parliament. But at the end of the day, my lord, all this material, all the views which have been collected by the National Assembly through its staff, it was to the benefit of the members of Parliament who are going to take the vote. It has not been suggested, none of the petitioners before you have suggested that any of the members of the National Assembly was unable to vote because they were not duly instructed by their constituents. There is none. If anything, only one MP of those who were able to vote abstained from voting. In other words, the members of Parliament were able to make choices based on the views they had gathered from the members of the public. But what was the outcome of the public participation exercise which was undertaken? Some 200 and 23,000 Kenyans submitted their views physically in the various offices of parliament. Probably the most intense and elaborate public participation exercise ever undertaken in this country. I think it mirrors the public participation which was undertaken prior to the adoption of the Constitution. I think that is the only other public participation session which rivals the adoption of the new Constitution. My Lord, views were received on email, others were received on the ex-handle of Parliament, and it was effectively utilized by the members. It has been suggested in one of the petitions that the format which was developed by staff of Parliament for collection of views was restrictive, that probably it should have been an empty page for Kenyans to write. It's our submission that, my Lord, it was more about accessibility, enabling Kenyans to digest the grounds and express their views. But any other Kenyan who felt that they needed to submit their views in a different format, and that's why the formats which were utilized differed in nature and character, they were at liberty to do so, and many did so. There were affidavits submitted, there was memoranda submitted, so there was no restriction to utilize that form. And the challenge on that ground, my Lord, is without basis, and it is for rejection, and we urge you to reject. It did not restrict any Kenyan to that particular mode. There is, allow me to then go to that link of the public participation by responding to some of the allegations which have been raised. But before I do so, allow me to submit and say, in terms of quality and the quantity, the National Assembly met the threshold expected of it in the Constitution, Article 10, Article 118, and also by the established jurisprudence of this court, the Court of Appeal, and the Supreme Court. The test required by all the existing jurisprudence has been satisfied and was satisfied. Now to respond to the issues which have emerged or have been raised by some of the petitioners, it was alleged, and I believe this was alleged or raised by the third petitioner, Honorable Njeri, that there were allegations of violence, intimidation, and disorganization in the public participation report. It is our submission, my Lord, that with the exception of Kerugoya, Kirinyaga County, and in particular Kerugoya Township, the National Assembly did not experience any issues of violence, intimidation, or disorganization. Why is Kerugoya important to know? That petitioner, I believe in her petition she identifies herself as the woman, the county member to the National Assembly for that particular county. The county office in that particular county was closed by herself, by the third petitioner. She closed her office and then rushed to court that same day to obtain orders before Justice Mwongo. And she did obtain those orders, but it prompted
action from the National Assembly. And in our annexure SN10, we have attached a letter from the clerk of the National Assembly addressed to her, raising concerns with our poor attempt
because we highlighted submissions, and I believe that the government council is including that Honorable Jerry closed the platform for public participation must be somewhere in the affidavit lodged. That the Lordship we guard ourselves against misleading this court, so that council and your Lordship may direct us to the affidavit that is currently highlighted that specifies that Honorable Jerry closed the platform where public participation is supposed to take place, Your Lordship. The council can guide us on the particular paragraph of the affidavit.
My Lord, I shall retrieve, I'll ask my colleague, Mr. Oma, to retrieve the affidavit. But there is an annexure to that affidavit, a letter from the clerk of the National Assembly addressed to her, raising concerns about why she closed the office and locked out members of the public from submitting their views. It was not a personal office. This is a public office paid by the National Assembly. There was no basis for her to close it. That letter, my Lord, is available, and I'm surprised, I'm shocked that my learned friend has not gone through it. Probably that's why these petitions are being filed on elementary questions, which are proven. My Lord, the material is there. If I could go on, then I'll actually read for the court the entire text of the letter. It's 2 pages. So that, my Lord, the conduct of the third petitioner, a supplicant before you, a person praying and seeking relief from this court, is that of reminiscent of an arsonist who starts off a fire, then runs to the police station to accuse people of starting off those fires, or seeks to be appreciated for putting off a fire they started. My Lord, save for that particular incident in Kirinyaga County, the entire country was peaceful. And my Lord, may I put it on record also that subsequently, on the second day, after His Lordship had granted had directed the National Assembly to cascade the public participation to constituencies, public participation did take place in all the constituencies in Kirinyaga County. So those allegations, my Lord, have no basis. My Lord, I've accessed the material which my learned friend Mr. Njiru was demanding. And I'm surprised, my Lord, because I was in court in this matter with Mr. Njiru. And there was palpable tension in Kirinyaga town. In fact, we had to be escorted by police to access Kirinyaga town on the day petition number 14 was coming up. Courtesy of the violence meted on the people of Kirinyaga by the third petitioner. I can state that from the back. But if my learned friend requires any evidence, then it is in paragraph 54, paragraph 53, and paragraph 54 of the petition.
And the objection I'm raising is raising allegations that the violence were initiated by the women rep, which allegations are not substantiated, and therefore we are opposed to that kind of submission.
Let's see if you have anywhere you can address this. This is a question.
I can supply to the court, my lord.
Paragraph 54.
I will, my lord. In paragraph 53, my lord, the deponent,
the clerk of the National Assembly states, it is important to note that in further compliance with the orders issued in the requirements, Petitioner Badis, Honorable James Jerry Minor has the Senate, National Assembly, and others. My office efforts to contact Honorable James Jerry Minor's county office to inquire why the Kirinyaga County Women's Office was closed during the public participation exercise. Despite parliamentary officers being deployed to assist the office staff, the office staff informed parliamentary officers that the closure was directed by the petitioner. This assertion has been on record since, I think, 6th of October last year, because we attended to the matter with Mr. Rigathi, and I filed an affidavit in that matter, and this assertion is there. It's not been denied. Further, my lord, we've attached the letter which was authored to that office by the clerk of the National Assembly. It's SN3. 3 pages. Why did
Your Lordship, I believe the paragraph that Council is referring to does not associate the Honorable Jerry Minor with the violence that Council is submitting on. Thus, my Lord, Council is restrained from testifying from the bar.
Paragraph 54, my lord, states, the staff indicated that Honorable Jerry Minor has ordered the closure because she opposed the special motion. Because she opposed the special motion for removal of the Deputy President, an action seemingly intended to frustrate the public participation exercise. What more do I do? I can appeal to the court of my learned friend. So my lord, public participation was effective with the exception of those challenges brought by certain individuals. But it is important to also note, my lord, that the Constitution does not demand a flawless process. It just demands that the people be given a meaningful opportunity to participate. And this, we say, my lord, the National Assembly did. If it was an exam, it would be an A. We've spent a considerable proportion of our written submissions, my lord, on that subject. I think it's from page 52 of our submissions to page 69. We would ask, my lords, to go through those written submissions because they address much more than I've been able to capture within the limited time available. Well, the second issue which has been raised in the petitions is that the National Assembly should have circulated the Deputy President's response as it undertook public participation exercise. There's a challenge by the first petitioner that his response to the issues which are being raised in the special motion should have been circulated together with the public participation template. My lord, it's our submission that considering the constitutional architecture of how impeachments are processed, that proposition from the past petitioner is not only untenable, but has not complied with the way impeachment proceedings are structured in our Constitution. I think my learned friend Mr. Gumba has taken you through the process through which impeachment motions are processed. It starts with a motion supported by a third. If it is not supported by a third, it doesn't become a motion. It's not even tabled in the House. So there is no opportunity at that point in time to ask the person who sought to be removed from office to give his views on the motion. Once the motion is well supported, it is tabled on the floor of the House. And subsequently, probably a committee of the House would be assigned to a committee to go through. My Lord, those processes, until such time that Parliament intends to vote, the National Assembly intends to vote on whether to approve it for trial by the Senate, there is no room for the views of the person sought to be impeached. And in this particular case, he was heard prior to the motion being voted on. And that is the procedure anticipated by both the Constitution and the standing orders of the National Assembly. It has also been alleged, my Lord, I believe this is from the third petition, that the public participation report was fabricated, or that it is cosmetic. They've thrown in quite some adjectives there. It's our submission, my Lord, that those allegations are not supported by evidence. The public participation report is a product of the House, of the National Assembly. It is in the answer of the National Assembly. It was considered by members of the National Assembly. It is authoritative, it's verifiable, and it's accessible. So it's not cosmetic, it's not fabricated. It was developed by the staff of Parliament based on the material they collected across the country. May I say, my Lord, that public participation report has been produced by the Speaker of the Clerk of the National Assembly to this court, together with the answer showing its adoption, and it has not been challenged other than through the submissions which were made by Madam Prime Minister. The Supreme Court in the Institute for Social Accountability and Another versus the National Assembly has affirmed that courts ought to take judicial notice of answered records as accurate reflections of parliamentary business. And this is not a forum to assert, especially for this third petitioner, because that allegation is also coming from the third petitioner. If they had a problem with the answer and the record of the National Assembly, especially herself being an MP, she had reasonable opportunities to raise it with Parliament. Besides, she should have denied it. It has also been alleged, and I should leave this to the Senate, that the Senate had a duty of independent public participation without prejudicing the submission which will be made by teacher Professor General. It is our submission that the Senate is a trial chamber. It is not. The senators, when considering an impeachment motion, sit as jurors. They try the facts, they test the evidence, and consequently, as a trial fact, they are not to be influenced by anything else other than the facts placed before them. In this case, by the National Assembly and the Deputy President. So that, my Lord, there is no duty to undertake public participation in the Senate. Allow me to address you on the last link on public participation, touching on the National Assembly. And this is with respect to the appointment and approval of Professor Kindiki as Deputy President. My Lord, this was adverted to by Senior Counsel Professor Gido Mwegere on the responsibility of the various actors when it comes to approval, nomination and approval of an deputy presidential candidate. Article 149, my lord, of the Constitution provides that within 14 days after a vacancy in the office of the deputy president arises, the president shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. It's our submission, my lords, my lady, that a contextual reading of Article 149 and a textual reading as well yields to the irresistible conclusion that when it comes to nominations, it is the president who nominates. It permits of no other interpretation. And the duty of the National Assembly is to vote on the nominee. And because they are required to vote on the nominee, it's our submission, my lord, that contrary to the assertions which has been raised in some of the petitions, that there was a requirement for public participation, it's our submission that on that particular process of processing the nominee to the office of deputy president, there was no requirement for public participation. Allow me then, my lord, I rest on the arguments in relation to public participation at various stages. I would only refer my lords, my lady, to our written submissions for their full effect and intent. Allow me, my lord, to then address you briefly on the authorities which have been submitted by my learned friends for the petitioners, especially the decisions coming from South Africa. My lord, I begin by submitting that with respect to those decisions, the Constitution of South Africa and that of Kenya are not in pari material nature. Those two decisions, probably three decisions, EFF 1, EFF 2, EFF 3, were rendered by the Supreme Court, the Constitutional Court of South Africa. When you look at the Constitution of South Africa, in Article 167, they call their sections, Section 167 of the Constitution, of their Constitution, 167(4)(e), with respect to the powers of the Constitutional Court. One of the powers conferred on that court is to determine whether Parliament or the President has failed to fulfill a constitutional obligation. It's a power conferred directly to inquire into the conduct of Parliament or the President and to assess whether they have failed to fulfill a constitutional obligation. And that constitutional scholars have written about it on the place of the Constitutional Court of South Africa in their democracy. So much so that the Constitutional Court of South Africa sits probably higher than the organs created in the Constitution, because it is enabled to question in a more elaborate way the affairs of all state organs. So what happened in EFF 2, and the proper citation of that decision is Constitutional Court Case number 76 of 2017, Economic Freedom Fighters as the first applicant and 4 others, so, and 3 others, together with Democratic Alliance as an intervening party, against the Speaker of the National Assembly and President Jacob Zuma. Now, in that decision, the EFF, a political party in South Africa, have sued Parliament for failing to implement the decision of a constitutional commission known as the Public Protector, which had established that President Jacob Zuma had helped himself to public funds, which he used to renovate his house in his rural home. And the public protector had directed that the president should pay back that money. Now, he didn't pay back. And the question became whether the National Assembly should have him impeached under Section 80, I believe it's 85 or 89 of the Constitution. Of course, the National Assembly, being dominated by members of the president's political party, did not vote to impeach the president. And EFF, another political party, went to court in these proceedings. They had gone to court in different proceedings, earlier proceedings. They faced a challenge, that was EFF 1. In EFF 2, the Constitutional Court directed Parliament, the National Assembly, to set up rules of procedure which would enable the processing of impeachment motions. Because there was a challenge as to which committee is to process that motion. My Lord, they did make those rules, and they were used in EFF 3, but I'll get there. But the concern which the petitioners before you raise now is that the reason why the Constitutional Court directed Parliament to make rules is because there was no opportunity for an inquiry to be undertaken. And the majority in that decision felt that it is wrong for members of the National Assembly to simply vote on a motion without anyone processing whether the grounds and the facts, the facts which have been laid can establish a ground for removal. So they say you must then have an inquiry panel or a committee, an impeachment committee. This is what they stated then at page 62 of that decision. We'll have an opportunity, my lords, to look at it. But they said that it is very important for an inquiry process to be undertaken to tie up the facts with the grounds which are in the Constitution. My Lord, in Kenya, we have a Senate which does exactly that which is problematic in down South Africa. We have a Senate which undertakes inquiry. So this decision, to the extent that it is being used for purposes of laying a basis for taking the impeachment proceedings to a committee, is not useful. It's not useful for petitions. But it is useful for other purposes. It's useful for the National Assembly. You notice, my Lord, that the Constitutional Court of South Africa is asserting that the values contained in their Constitution must be enforced. And that is why they are forcing their National Assembly to enact rules, to create procedures for processing. Why? Because they are saying if someone has helped themselves to public funds, they must be held to account. And this decision is about accountability by those in public office. Now they are asking you, my Lord, to do the opposite, to protect them from accountability. That's what they want, to use this decision to jettison parliamentary proceedings, which where our own National Assembly has held a deputy president to account. Yet the South African National Assembly did not hold theirs to account. The Constitutional Court intervened. They're asking you to do the opposite. Don't do that, my lords. Don't. You will be doing the opposite of what the South African court has done. Now, it becomes more poignant, my Lord, when it comes to EFF 3, the decision which was rendered last Friday. Again, almost similar facts. President Ramaphosa helps himself to process some money from somewhere. It's in foreign currency. He doesn't declare it. And some thieves go to his house, they steal it. he is stuck. How can you report to the police? Money is foreign currency which you have not declared. It causes his security officers, personal security, presidential guards, to go and look for those fellas. Makes a call to the president of Namibia. Says, one of my citizens is in your country with my money. Long story short, it is investigated. It is found that he had not reported that incident to the nearest police station in breach of their constitution. EFF goes to court and says, at least this time around, this is now case number 35 of 2024. Between 2017 and 2024, National Assembly established rules, establishing a panel of inquiry and an impeachment committee within the standing orders of the Assembly. So a panel of inquiry investigates, finds the president culpable, a report is tabled. ANC uses its majority to jettison the report. Now the Constitutional Court is saying, no, you cannot jettison this report before it is tabled, before the panel of inquiry. Again, they are seeking to hold the president to account. Now, the petitioners before you today are asking you to use this authority so that a person who has already been held to account can escape. Don't do that. Stand with your counterparts in South Africa. All public officials to account. My Lord, they spent 12 hours to make submissions before you. Not once, and I tried to listen, not once did they mention the word accountability, yet it's a value in Article 10. Not once did they mention the word equity, it's a value in Article 10. Not once did they mention the word inclusiveness, it's a value. To them, the only value they mention time and time again is public participation. Please, I would ask you, my Lord, look at all those values. Because the impeachment motion which was before you was enforcing those other values they don't care to mention. I rest my name.
Thank you.
How many councils are here in the Senate? How many will be addressed?
Yes, if it pleases you, my lords, I will go first. I will address the Senate, the court for about 1.5 hours max. And then my other friend, Mr. Mukele Moni will go after me, and then Mercy Kanji will conclude by analyzing or submitting on case law and responding on various legal questions. I will try, my lords, to ensure
How much time do you want to spend?
a maximum 1.5 hours on the part. 1 hour, 1.5 hours maximum. I am normally very brief.
No, I'm asking how much time do you want to spend as a unit?
2 hours, I think 2 hours. 2 hours should be sufficient. 2 hours, 2.5. Yes, 2.5 hours max.
That will take us to what time?
That's about 6:30, 7 p.m. Which is early.
I think we will proceed and adjourn at 6 exactly. When the time reaches 6 p.m., we will automatically stop and go home.
Yes, thank you, my lords. My lords, if I may start by just setting out what we have filed as Senate. We have filed a replying affidavit by the Honorable Clerk Jeremiah Jegenye, and the affidavit is sworn on the 21st of October 2024. It is filed in E565 of 2024. My lords, the second document on record is the affidavit by Jeremiah Jegenye, sworn on 21st October 2024. It is in E0.
The same day.
21st October, yes, but we filed it in different files, yes. So now then, we have written submissions dated 24th April 2026, filed on 25th April 2026, and lastly, in response to the application, in response to the affidavit of Dr. Tukonyo, we have filed an affidavit of Jeremiah Jegenye, sworn on 11th May 2026, and our friend Mr. Mukele will deal with that part of the response. I just want to bring the court's attention to 2 points before I commence my submissions. Now, what we are dealing with here is a serious national question, because the impeachment of a deputy president was undertaken or is undertaken directly under the Constitution, because no act of parliament has been enacted to separate or to modify the impeachment of the deputy president from that of the president. And my lord, I will then ask the court to note that the impeachment therefore questions the authority of the president here in deputy president under both Articles 131 and 147 of the Constitution. My lords, under Article 131, the president is the head of state and government, exercises the authority of the republic with the assistance of the deputy president and cabinet secretaries. He is commander-in-chief, the symbol of national unity. But my lords, in terms of the functions of the president, this is important, my lord. The president not only performs functions described under Article 132, but these functions, my lord, include national functions, security functions, but also international functions, functions that include engaging heads of states, signing international instruments, and presiding over international meetings, such as the one we witnessed yesterday. My lords, Article 147 is instructive. It then says, my lords, that the deputy president shall perform duties as assigned by the president. Which means, my lord, that the deputy president, while in office, performs those duties that are set out under Articles 131 et sec. As he is the personal assistant, principal assistant to the president, and shall deputize the president in the execution of presidential functions. Why am I citing these articles? 147, 131, 132. It is because, my lords, you have been asked in petition E565 to set aside or to find that the impeachment of the former deputy president, Rigathi Gachagua, was undertaken in violation of the Constitution. My lords, I move straight to Article 145(7). My Lord, in spite of the processes as defined under Article 145, I wish to read Article 145(7). It says, once the motion has gone through the National Assembly and is considered by Senate, it states, my Lord, if at least 2/3 of all members of the Senate vote to uphold any impeachment charge, the President, hearing Deputy President, shall cease to hold office. Any, my Lord. The charge may be a silly charge, it may have no substance, it may not bear on certain provisions of the law, but once it is passed by Senate, then the impeachment is final. My Lord, the import of the provisions of Article 145(7) is that, my Lord, once Professor Kindiki was sworn in as Deputy President of the Republic of Kenya after the impeachment of Rigathi Gachagua, that was an act final. It was a final act because the impeachment was final. In pari materia, my lords, petitioners have submitted and are inviting this court to consider the possibility of nullifying the process that finally led to the impeachment. And in various prayers, my lords, they have sought compensation. My Lord, any finding by this court that takes back the Republic to the pre-impeachment time, my Lord, that is to 17th, when the impeachment occurred, my Lord, would create or breed a constitutional crisis. Why, my Lord? Because it would then question various acts of state. It would question various acts of state prescribed under Articles 131 and 132, would question those acts or actions that would have been undertaken by the Deputy President. It would also then question, my Lord, the finality of Article 145(7) of the Constitution. I dare submit, my Lord, that given the wording of Article 145(7), and given the nature of the processes as prescribed by the standing orders, and I shall submit on all the headers, my Lord, this court must uphold the impeachment and find that it was final as contemplated by 145(7), and that Rigathi Gachagua was duly impeached and Professor Kindiki assumed office in accordance with the Constitution. No damages or no compensation can therefore lie, and no reprieve, my Lord, can lie, as I will demonstrate that all the processes that the Constitution set down were complied with. My Lord, first, to Article 145(3). My Lord, you have been told that Senate ought to have sat by committee, or ought to have proceeded by committee, and had no option to use the plenary in the impeachment proceedings. My Lord, on this question we wish to submit as follows, my Lords, that Senate deprives its power to impeach under Article 96 of the Constitution. Indeed, Article 96(4) provides that Senate participates in the oversight of state officers by considering and determining resolutions for removal of the President or Deputy President in accordance with Article 145. My Lords, Article 145.3 then prescribes the timelines. That once a resolution of the National Assembly is received, within 7 days, the Speaker of Senate shall convene a meeting of the Senate to read the charges. This was timelessly done and undertaken on the 9th. My Lord, pursuant to Article 145.3b of the Constitution, Senate, and because of the use of the word may, had the discretion to either appoint a special committee to investigate allegations regarding the impeachment of the Deputy President or proceed as a whole, my Lords. My Lord, Senate proceeded under Standing Order 78, which provides for the procedure of impeachment. My Lord, Standing Order 78.9, which prescribes the mode of impeachment, provides that the Senate can proceed as a committee of the whole or appoint a special committee to conduct investigations into any matter before Senate in accordance with the rules of procedure prescribed under the second schedule of the Standing Orders. My Lord, we submit that Senate proceeded under Standing Order 78.9 and duly, a motion was duly tabled to appoint the special committee before Senate. That motion, tabled by Senator Aaron Cheriot, the majority leader, was defeated on the floor on the 9th October 2024. And this was a motion moved under Rule 2 of the second schedule of the Senate Standing Orders. But where the motion failed, or once the motion failed, Senate could not and did not abdicate its responsibility to proceed as ordinarily, the matter falls back to the whole House, my Lord. Standing Order 70, my Lord, of the Standing Orders of Senate provides that once a motion fails, or in this case, once the motion for impeachment by committee failed, the impeachment fell back to the plenary and was undertaken by the plenary, which was the whole House of Senate. Submissions have been made, my Lord, that the Committee of 11 is the ideal body to investigate any matter before Senate. My Lord, once the matter is in Senate, it is the Senate sits as a quasi-judicial body with the 68 senators sitting as jurors, my Lord. The motion, my Lord, then provided that Senate would investigate the matter in plenary on the 16th and 17th October 2024. And as such, my Lords, the fourth respondent conducted the impeachment in plenary pursuant to Part 1 of the second schedule to the Senate Standing Orders. My Lord, if I may just explain the relationship between Senate and the committee. My Lord, the Senate is the principal and the committee is the agent, so that the Senate and the committee have a principal-agent relationship, so that the committee are agents of Senate and the committees enable the legislature to organize its work in a way to perform numerous activities simultaneously and expeditiously. Had the Senate proceeded by way of a special committee, the committee would be acting as an agent of the House. And the standing orders, my lords, reinforce that committees consider matters and report back to the House. And usually, when a committee undertakes the work of impeachment, for instance, the report then would be tabled in the House for adoption or rejection, my lord. And since Senate committees are creatures of Article 124 of the Constitution, the standing orders therefore have a force in law, just like any other provision of law, my lord. It is what, my lord, would be referred to as delegated parliamentary authority, where the committees then operate as agents of the main house, undertaking inquiry, scrutiny, and finally reporting back to the House. But, my lord, of importance is the discretionary provision of the Constitution, that Senate may and not shall investigate through committees. It is this discretionary power, my lord, that cements the position of Senate and gives legality to Senate having had the option of adopting the committee way or proceeding in plenary. And my lord, just in comparison, we have referred to Article 152(6) that allows the National Assembly to impeach or to pass motions requiring the President to dismiss cabinet secretaries. My lord, that standing order is couched, or that provision is couched in a mandatory term. It says the Assembly shall appoint a select committee, Article 152(6). Now that is different from Article 145. Had therefore the people of this country, my lord, intended to make it mandatory for the Senate to proceed by way of committee in the impeachment of the President or Deputy President, nothing would have been easier than for the express text of the Constitution under Article 145(3) to state so. But instead, my lord, the Constitution uses the word may and not shall. A lot of submissions, my lord, have been made by learned friends for the petitioner that shall means may. We submit, my lord, that no amount of submission from a learned friend, Mr. Dudley Ochel here, can change the text of the Constitution, because may gives an option, and that is why Senate fell to the option after the defeat of the motion under Standing Order 70, my lord. My lord, on the question of discretion, I wish to rely on the case of Sonko and the Clark County Assembly of Nairobi, which is a Supreme Court case number 76. And my lord, I think I argued this one in part. The Supreme Court emphasized that Parliament has the discretion, always has the discretion, where there is no compulsive use of certain words, my lord. In other words, where Parliament is required to determine a matter in the first place as part of its constitutional mandate, it has the discretion to regulate its own affairs, and the courts will be slow to interfere with the exercise of that discretion. My lord, we point to 145(3) on the question of discretion. Impeachment proceedings, my lords, were and are conducted in accordance with the Senate standing orders pursuant to Article 124 of the Constitution and are subject to strict timelines. And that is why, my lords, in addressing the question of timelines, which falls squarely on all the issues that were determined by Senate, including, my lord, the question of adjournment, which did not fall upon the Speaker to make a determination. It fell upon Senate sitting as a quasi-judicial organ to make any decision touching on the process. My lord, it is these standing orders that provide the necessary anchor to processes that are undertaken in Senate, in which case, my lord, impeachments cannot be undertaken without recourse to these standing orders. Given, my lord, that we do not have an act of parliament or a statute that would be a normative derivative of the Constitution on the question of impeachment to define standards for the impeachment of a deputy president. So we fall to the text of the Constitution in this process. My lord, in the matter of the Speaker of Senate, another Supreme Court decision, my lord, this is what the court had to say, the Supreme Court had to say on this question, my lord. That the drafter of the Constitution, no doubt knowingly, used the term may, which is permissive, my lord, implying that the exercise of this jurisdiction is discretionary. The courts observed as such in the matter of IEBC, the Interim Independent Electoral Commission, where the court stated at paragraph 34 to 82 that insofar as the jurisdiction reposed the Supreme Court under Article 163(6) of the Constitution employs the directory term may, it is, in our opinion, purely discretionary at the instance of the court. It may be emphasized that the advisory jurisdiction of the Supreme Court under 163(6) is discretionary. But no, that was an interpretation of the powers enjoyed by the Supreme Court under Article 163, 4A, 4B, and 6 on advisory opinions, my lord. My lords, on the same principle, my lord, the court in Cooperative Bank Limited and Banking Insurance and Finance Union are also dealt with the use of the word may. I'm just trying to seal this point so that Mashere does not speak about it again. The court proceeded, my lord, that our understanding of the act is that prescribed remedies, including restatements, are discretionary rather than mandatory, to be granted on the basis of the peculiar facts of each case. This is made clear by the use of the word may, which in the context of the provision imports a discretionary rather than a mandatory meaning. That the remedies, including restatement, are not a mandatory remedy is even made clearer by section 49(1) and 13 Constitution set out by the court. My lord, the use of the word may seems to be cemented and cast in stone insofar as the several interpretations by the Supreme Court where the textual use of the word may seems, my lord, to permit actions, my lord, and therefore, in finality, we submit that in using the word may, Article 145 mandated Senate to proceed in the manner it did by choosing the mode of proceeding and dropping the mandatory mode, my lord, which as petitioner submitted that they should have proceeded by way of committee, my lord. Senate proceeded by way of plenary as the motion to proceed by way of committee had been defeated in a motion presented by the Senate majority. My lord, I wish to proceed to the second point, which is a submission, my lord, by my learned friends that there are no timelines in the impeachment process, and therefore, my lord, when an adjournment was made on the 17th, the Senate should have indulged the then Deputy President, Rigathi Gachagua, and allowed the impeachment to proceed the following Tuesday, or on the 18th, that is the following day, which would have been a Saturday, or on the Monday, my Lord. My Lord, the second schedule of the Senate standing orders provides that once the Senate sits to consider a motion for impeachment, all other House business is suspended. Indeed, my Lord, Rule 12 of the second schedule of the Senate standing orders provides that once the hearing of an impeachment motion commences, it shall continue until Senate concludes the hearing of the matter. It was therefore incumbent, my Lord, upon Senate to continually hear the impeachment charges from beginning to end, as that is what is donated by Rule 12, my Lord. And given the stringent constitutional timelines governing the impeachment process, my Lord, time could not be halted or delayed once the process had been set in motion. My Lord, Article 145 and 150 of the Constitution, read together with the Senate standing orders, prescribe clear procedural timelines that must be adhered to, ensuring that the impeachment proceedings are conducted expeditiously and efficiently. My Lord, the Senate would therefore not pause these hearings, adjourn them, my Lord, unnecessarily, as that would violate the constitutional provisions and disrupt the delicate balance between fairness, accountability, and prompt resolution of serious matters. My Lord, once the proceedings commenced, they not only assumed they were not only proceedings of judicial nature, but had political ramifications, my Lords. So that learned friends have submitted or are submitting as though these were normal proceedings. But Lord, these are the proceedings touching on the impeachment of a Deputy President of the Republic of Kenya. And therefore, my Lord, several issues, including delicate issues of national security, national safety, and several issues, areas of accountability, my Lord, were on trial. The petitioner, therefore, ought not to be accorded an opportunity to challenge proceedings that he opted out of. My Lord, this is the point, my Lord, that the standing orders gave timelines for appearance and the reading of charges that occurred on the 9th. It took another 8 days for the trial to convene on the 16th and the 17th. The petitioner had sufficient time between the 9th and the 16th to file pleadings. And my Lord, he had the best of counsel in this republic. His legal team was led by none other than Paul Mwita, Senior Counsel, a seasoned Senior Counsel, and Mr. Ongoya, Senior Counsel, and other counsels sitting here, including Mr. Mashari Ahmed. He had the creme de la creme, and cannot claim, my Lord, that he was never afforded an opportunity to be heard. My Lord, the Supreme Court, in the Sonko case, has warned against delays in proceedings, because what is complained of here, my Lord, is that the processes of impeachment and the hearing leading to the impeachment of Rigathi Gachagua was undertaken with God's speed. Or as my lion friend Mr. Masharia said, with goon speed.
No, he said ungodly speed.
Well, it is with godly speed, my lord, because the Senate, my lord, the Speaker, gazetted 10 days within which to hear, to conclude the proceedings, my lord. My lord, within that time, pleadings were filed by all parties, and all parties appeared during the hearing. My lord, in the Sonko case, this is what the court stated, my lord. While on this question, it is important to observe that the multi-stage nature of the process of removal from office and the attendant litigation that follows have produced in the recent years a worrying trend that, in our view, amounts to abuse of court process by parties. Parties employ all delaying tactics in the book to avoid the consequences of the lustration provisions, chapter 6 of the Constitution, that disqualifies an individual from holding a state office, and so on and so forth. My lord, the court addressed the question of the timeless conclusion of proceedings. My lord, it is not true that the petitioner was not allowed to participate in the proceedings before Senate. Indeed, he fully participated. He sat through the proceedings. And my lord, let me just demonstrate what he did, my lord. My lord, the petitioner made an opening statement through his advocate, who was none other than the eminent senior counsel, Elisha Ngoya. Secondly, my lord, he was granted an opportunity to cross-examine witnesses of the National Assembly, including the mover of the motion, One Honorable Ekomas Mwengi Mutuse. He cross-examined Mutuse. And my lord, he also filed his response to the particulars of all the allegations before Senate, and in respect of all charges. Fourth, my lord, the petitioner filed a witness affidavit sworn on 12 October 2024, and a further witness affidavit sworn on 13th October 2024, which were in volumes, my lord. And lastly, he filed indices and a bundle of documentary exhibits together with video evidence in support of his case. My lord, this will become important in the end and will demonstrate or will show why certain charges failed. Because not all charges were proved against the petition. He had excellent counsel prosecuting his case and defending him before Senate. My lord, why then did Senate decline the prayer for adjournment? My lord, this part of my submission is interconnected with the response that shall be submitted upon, my lord, by my learned friend, Mr. Mukele. But my lord, we'll go to show that every opportunity was afforded to Paul Mwite Senior Counsel and the petitioner at the time to conclude the hearing. My lord, on 17th October 2024, Senate concluded the hearing of the National Assembly's case at 1:15 p.m. The petitioner, the Deputy President then, Rigathi Gachagua, sat through all the proceedings and was all smiles in court. At 1:15, my lord, the Speaker directed that upon resumption of Senate hearing at 2:30, the Senate would hear the Deputy President, Rigathi Gachagua, for 2 hours. The 2 hours that you've given us today, my lord. My lord, when the House convened at 2:30 p.m., and this is all in the affidavit, my lord, of Jeremiah Nyegenye, sworn on 21st October 2024. When Senate resumed at 2:30, my lords, counsel for the petitioner, Mr. Paul Mwite Senior Counsel, sought time to establish the whereabouts of his client, who whom he had walked out of court at 1:15, my lord. He walked him out, and then he suddenly disappeared into thin air. And when he came back, my lord, at 2:30, he told Senate that his client was no longer visible. But, my lord, to add to that, he then stated that he had made a phone call to his client, but had been told that his client had been taken ill. My lord, what the Speaker did then was to suspend the proceedings of the Senate to 5 p.m. to allow counsel for the Deputy President to report the status of his client. My lord, counsel was invited by the exercise of discretion of the Speaker and given 2.5 hours to report on the status of his client. And the report, my lord, was simply for counsel to provide evidence as to where his client he had information as to the whereabouts of the petitioner. But then, my lord, he had a caveat. He stated that he was not able to access or talk to him. And he sought an adjournment to Tuesday, the 22nd October 2024, to enable his client attend to his doctors. My lord, it is that report that the court considered today and that Dr. Gikonyo testified to today, my lords. It is that report, my lord, that states that the Deputy President then would be discharged from Karen Nostro 31 days later. My lord, at this point, due to the nature of the proceedings, because this was a proceeding by the plenary, it was incumbent upon the Speaker to seek a motion to be tabled for Senate sitting as a quasi-judicial body to make a determination. It was not upon the Speaker to make that determination. And my lord, this is where the question of the independence of institutions and whether, my lord, the court can question whether Senate at that point exercised its discretion properly, or, my lord, whether it is open to court to consider, my lord, the finality of the proceedings in Senate as donated by Articles 145(7). My lord, that article then says that any motion, however, my lord, that brings me to this, apart from the other cases that I will refer to, 145(7) states that if at least 2/3 of all members of the Senate vote to uphold any impeachment charge, however hopeless, the President or hearing Deputy President ceases to hold office. My lord, Senate exercised its discretion against granting the adjournment on the 17th to Tuesday, 22nd October 2024, as said. My Lord, this was a vote by Senate, sitting as 67 members. My Lord, when Senate sits as a committee or as a quasi-judicial body, the standing order provides that they enjoy powers of the High Court. So, my Lord, these were 67 judges, 67 judges, including the judge from Embu. 67 judges, my Lord. In response to the request, my Lord, the Speaker then ruled in line with the vote from Senate, rejecting the request for adjournment. My Lord, that was after a supplementary order paper had been circulated in accordance with the rules and my Lord, Rule 12 provides that once the motion commences, it must be executed to the end. My Lord, what the prayer for adjournment sought by Paul Mwite's senior counsel would have violated the provisions of Rule 12. Because then Senate would have then had to gazette a new date that was not consequential. Perhaps had the application provided that Senate seeks the following day, which would have been the 19th, Senate would have perhaps considered voting for the motion because it would have been, my Lord, in consonance with the standing orders. My Lord, once the motion was defeated, it was moved by Senator Aaron Cheriot, but failed, my Lord. The Speaker then folded his hands. He could not, as a presiding Speaker of the impeachment motion, my Lord, make any decision other than what the majority of senators passed, which was that the impeachment proceed, my Lord. My Lord, at the time, and this instructed, my Lord, no evidence had been tabled before Senate on the medical status of the first petitioner. Senate, therefore, had no material before it to enable it exercise discretion in favor of the first petitioner. Number two, my lords, no testimony from Dr. Gekonyo or any other doctor in the panel of consultants or other assisting doctors had been provided to Senate. My Lord, the belated filing of an affidavit by Dr. Daniel Gekonyo, which was filed the other day, cannot amount to a sufficient compelling ground before Senate, because, my lords, it not only comes too late in time, but comes after Senate had, sitting as plenary, concluded its work by having a vote denying the adjournment, my lord. My lord, what is the effect, and this is just something that is coming right on top of my head. What is the effect, my lord, of the court finding that there were grounds that would have enabled Senate to allow an adjournment? My lord, even if the court considers that the evidence provided today of several chest pains and other illness by the Deputy President at the time, my Lord, and that evidence is availed after 1.5 years of the sitting of Senate, my Lord, the court cannot correct that anomaly, as then the court would be acting not only retrospectively, but would then be faulting the act of Senate undertaken in good faith on the basis of material before it. But my Lord, let me also point out to one thing, that Mr. Paul Mwite, Senior Counsel, my pupil master here, and Mr. Ongoya, once they realized that they had no evidence of any sort, material, medical, or otherwise, including even call logs that he had made to the then Deputy President, they folded their hands and walked out. In fact, I remember Senior Counsel walking out and leaving Senate. Although it is impossible to bridge the evidentiary gap that made Senate to reject an adjournment. Lord, the Court of Appeal, in Solo Kandie and James Kwambai Cheriot, defined what constitutes an opportunity to be heard. As we submit, my Lord, that the petitioner was afforded every opportunity and was heard by Senate substantively for the Senate to have been able to arrive at a decision to impeach. My Lord, one, the opportunity to be heard, one is that an opportunity to be heard must be a full one, to wit where one voluntarily appears. Rigathi Gachagua appeared in the proceedings before Senate. My Lord, he had a chance to call witnesses. 3, my Lord, the opportunity must avail the witness the presentation of any relevant documents and must be fully heard. My Lord, in this instance, the petitioner presented and filed all documents before Senate. The court then concludes, my Lord, that the first is that the opportunity to be heard per se must be given. It was given, my Lord. The second is that the opportunity must be reasonable. It was reasonable. We had from the 9th to the 17th. 3, both these matters are justiciable, and it is for the court to decide whether an opportunity has to be given and whether that opportunity is reasonable. My Lord, that is why before you, and that is why we are submitting, my Lord, that in the exercise of its discretion, Senate, not having been afforded an opportunity to interrogate the health status of the petitioner at the time of the hearing before Senate, my Lord, arrived at a correct finding by denying the adjournment sought for on the 17th, my Lord. My Lord, in Skogan and the city of Overland Park, which is a decision from the state of Kansas, the U.S. District Court had this to say about an opportunity to be heard, my Lord. And this is what the court stated, that the plaintiff had a full evidentiary hearing before the Civil Service Commission. This was a case, my Lord, where a challenge was made on a party who was challenging actions by the commission My Lord, he then stated that he was represented by an attorney who had the opportunity to make an opening statement, like Ongoya did, but chose not to. And we examined the plaintiff and plaintiff witnesses, cross-examined defendants' witnesses, presented documents and other evidence through witnesses. Paul Mwita Senior Counsel did all this, examined all the witnesses, and made a closing argument. The plaintiff also had the opportunity to testify on his own behalf. It is only this part that is in question, my Lord. And finally, my Lord, what else would a party have testified to in addition to the documents that they had filed in court? The plaintiff, my Lord, or petitioner in this case, has not told the court that there were other grounds other than the grounds that were set out in the pleadings filed that he had intended to testify to and that would have absolved him from the various charges, including the charges on shares. My Lord, what we had in court instead, my Lord, was a justification by Mr. Macharia and Mr. Ongoya that every government is founded on shares.
No, this government.
That this government is founded on shares. My Lord, that certain sections or parts of the country can be excluded from the sharing of government is a gross violation of Article 10 and Article 6 of the Constitution. And I think that is common ground, that you cannot govern by a minority or by tribes and exclude other tribes. My Lord, the testimony of counsel alone justifying some of the grounds, my Lord, would have been grounds to be presented before Senate and were duly presented and voted upon by Senate. I don't think there was anything else that counsel would have testified to before Senate to influence or that would have influenced the outcome of the impeachment proceedings before Senate. My Lord, the Constitutional Court of South Africa, in economic freedom fighters and the Speaker of the National Assembly, and the jurisprudential landscape of South Africa is important because of the justiciable nature of some of the decisions of the houses, my Lord, but also some of the groundbreaking decisions of the Constitutional Court. That is why we refer to them. And because the South African Court, Constitutional Court, has paid homage and perhaps laid foundations for certain principles, including fair hearing and what the petitioner considers his best argument, that is public participation, my Lord. The Constitutional Court, my Lord, the EFF case, my Lord, found that the president, this was an impeachment question, must be afforded a fair hearing. But, my Lord, fair hearing, as the court found, cannot be interpreted to exclude the possibility of documentary or recorded evidentiary material, which will help the Assembly determine the existence of any ground of impeachment or the seriousness of any constitutional breach. My Lord, we cite this authority in support, though in pari materia, but in support of the notion that having filed documentation, having filed pleadings in compliance with the orders of Senate to support the grounds opposing the impeachment, my Lord, it cannot lie in the mouth of the Deputy President then to say that he had no opportunity to defend the impeachment charges against him. My Lord, this is again soundly captured in the Sonko decision, the Supreme Court, my Lord, that the Supreme Court stating, my Lord, that while still on this process, it is important to observe that the multi-stage nature of the process of removal from office and the attendant litigation that follows are produced in the recent past a worrying trend that in our view amounts to abuse of court processes by parties. The question of delay. We submit, my Lord, that this court should not only find that the timers and continuous proceeding contemplated by Standing Order 12 that led to a final outcome and vote by the Senate, my Lord, must be shielded from question, my Lord. Because these are proceedings before an independent body, the Senate, and I'll refer to the matter case that I argued at the Supreme Court on the need to respect proceedings before other bodies, my Lord, and to shield those decisions from question. My Lord, I will let my learned friend deal with the last question, but let me deal with a question that was raised again by learned friends, or that Senate voted on a ground, or ground 8, which was founded on a repealed section of the Penal Code. My Lord, yes, my Lord, if I may go to this, my Lord, the caveat, of course, on this ground, my Lord, is that one, this court cannot undertake a merit review of the proceedings before Senate. And that is why I alluded to Article 145(7) on a motion passed, however voted upon by Senate. But nevertheless, my Lord, since my learned friend from this side, again Macharia, dealt with this question, I must respond, my Lord. My Lord, this ground 8, that they allege was based on a repealed section of the Penal Code, my Lord, was not substantiated. Senate voted against it. And again, I state, my Lord, that the establishment of one ground was and is sufficient to send the petitioner home. Of the 11 charges, my Lord, presented to the fourth respondent by the second respondent, only 5 charges were substantiated. 6 were dismissed by Senate in its own wisdom. My Lord, why we submit that you cannot undertake a merit review, my Lord, is because this court cannot sit as Senate. And if this court begins a merit review on every ground, the 11 grounds, and finds, for instance, that a ground unsubstantiated was substantiated, then this court will essentially be taking over the role of Senate. And since an impeachment is a quasi-judicial exercise couched in real politique, my Lord, this court would then be judicializing politics. You then convert those other questions, my Lord, to a judicial examination, and that would fly in the face of independence of the 3 arms of government as contemplated by the Constitution. My Lord, ground 1 was, for instance, carried by 54 votes. Ground 2, negative by 39 votes. It was defeated. The allegation in ground 2, my Lord, was that Deputy President Rigathi Gachagua had undermined the president and the cabinet, and this was defeated. My Lord, ground 3, which was founded on Article 10.2, and which was that the Deputy President Rigathi Gachagua had undermined devolution, was defeated. The wisdom of Senate, always. My Lord, again, just to demonstrate to the court, ground number 7 again was defeated, and the charges were that the Deputy President, Rigathi Gachagua, was engaged in the crime of money laundering. That was defeated by 53 votes to 13. And lastly, my Lord, ground number 8, which was, my Lord, that the Deputy President Rigathi Gachagua had committed crimes by continuously misleading members of the public through false, malicious, divisive, and inciting remarks, again was defeated by 40 votes to 27. My Lord, lastly, ground number 10, again, which was on gross misconduct by Rigathi Gachagua by openly or publicly insubordinating the president as head of state and government, again, this was defeated. My Lord, all the other 5 grounds were votes were passed in favor of the impeachment, but Senate rejected 6 grounds. In fact, the petitioner should be thanking Senate for doing a good job and for rejecting 6 charges. My Lord, lastly, my Lord, is on public participation. I will just touch a bit on public participation and allow my learned friend to proceed from thence. My Lord, a textual reading of the Constitution and a purposive interpretation of the Constitution, or what Macharia would refer to as a holistic interpretation, shows that Parliament, and the term used is Parliament, apart from where, or except where, excepting where the Constitution then says Senate sits after the National Assembly. Parliament is referred to as the body that is intended to undertake public participation. And therefore, my Lord, in considering the textual provision of the Constitution, the court must then go further and look at the standing orders of both Senate and the National Assembly. We submit, my Lord, that the standing orders of Senate do not contemplate public participation for purposes of informing its decisions on the impeachment charges. Once the court sits, or once the Senate sits as a quasi-judicial body, it considers matters before it with a judicial eye, not a political eye, my Lord. And consequently, the allegation that the effect that the fourth respondent or Senate ought to have conducted public participation is not only misguided, my Lords, but is lacking on a legal basis. Senate considered the motion of impeachment from the National Assembly within the timeframes donated by the Constitution and Article 145(3) of the Constitution, and sat exclusively as a quasi-judicial body for purposes of determining all the charges against the then Deputy President Rigathi Gachagua. It was under no obligation to conduct public participation as it is not provided for in the standing order. But my Lord, again, it would have been ridiculous to expect Senate to undertake public participation on the charges. That would, my Lord, amount to Senate not only surrendering or ceding its power of trial, but engaging in acts that would not only be in violation of the Constitution, but of the standing orders of Senate, my Lord. The second respondent undertook rigorous public participation conducted between the 2nd to the 5th of October 2025. My Lord, on this question, the Supreme Court has pronounced itself on the practicality of subjecting every single act of Parliament to a fresh round of public participation. And this was in Cabinet Secretary of National Treasury versus Okia Okoiti Omtata and 52 others. The court input from the process on public participation, it would be circuitous and not amount to prudent use of public resources to expect the National Assembly, in this case, Senate, to subject proposals, views, suggestions, and input from public participation exercise to a fresh round of public participation. My Lord, with the knowledge that impeachment was occurring, my Lord, the National Assembly having subjected the process to public participation, what use, my Lord, would the exercise have served had Senate involved itself in a second round of public participation? But secondly, my Lord, in terms of timelines donated by Standing Order 12 of the Standing Orders of Senate, my Lords, any attempt to undertake public participation would have not only lengthened the period donated by the standing orders for impeachment and or the submission of any reports before Senate. That would make impeachments, my Lord, open-ended and unable to serve the very purpose for which the Constitution provides impeachments, my Lord. My Lord, lastly, we wish to submit on thresholds, and this goes to the question of the restraint that we have addressed the court on. My Lord, my learned friend Ndegwa Njiro and my learned friend Mr. Ochiel submitted on the question of threshold. And the Martin Nyaga Wambora case and the Speaker of Senate was cited. I think I litigated this one with Mr. Ndegwa Njiro and others, and Paul Mwite at some point in the Court of Appeal. The Wambora matters, my Lord, were several. But, my Lord, to wit that, and I fall back to 145.7. It is not open, my Lord, for the court to consider threshold once the National Assembly, by a vote of 1/3, admitted the charges or the grounds of impeachment before it, and once Senate, by a vote of 2/3, voted on the substance of every charge. At this point, my Lord, the court cannot find that the threshold for impeachment was not met. That would not only, my Lord, amount to violating you'd be relating back, my lord. The court would then be acting, 1 sitting as Senate, and 2 sitting as National Assembly, and 3 sitting as elected senators, my lord. My lord, I urge you to resist the urge to be elected members of Senate. My lord, I urge you, let me rephrase, my lord. I urge you to resist the urge, my lord, to sit as Senate. Thank you, my lord. My lord, I urge you to reject the argument by my learned friend Mr. Ochiel and Mr. Masharia that there was a threshold question, because that is for Senate and the National Assembly to consider, my lord. My lord, several decisions have been cited in support of this ground. We have cited the Sonko decision on impeachment. We have the Wambora decision is on the standard. The Wambora decision was on whether certain acts constituted a gross violation of the Constitution. And the court then found that the Assembly needed to establish grounds not on a balance of probability, but above the test, in fact, beyond reasonable, to show that some of those acts or actus by the petitioner, then Governor of Embu, my lord, were acts that were impeachable. My lord, the Court of Appeal was setting standards for impeachment so that we do not have willy-nilly impeachments without a basis, my lord. My lord, unlike, and this is distinguished in the Wambora case, my lord, the Wambora case must be distinguished from the Gachagua case. The Gachagua case had 11 charges. 5 succeeded, but 6 failed. My lord, for an impeachment to be successful, only 1 charge must succeed. Only 1, my lord. The submission on threshold, my lord, was therefore improperly made before you because it did not address every charge. In fact, it avoided addressing the successful charges. Instead, Daniel Friend-Degwa focused on the charges against which Senate voted. My lord, if I may cite the case of Kidero and Waititu and 4 others, this was a decision of the Court of Appeal that invalidated a decision of the Supreme Court that set aside a decision of the Court of Appeal that had invalidated the election of Evans Kidero and Mweke as the governor and deputy governor of Nairobi County. And while considering this question, the Supreme Court dealt with the question of fair hearing. I think this is one of the cases that set out the question of fair hearing. I think this point was urged by Senior Counsel Paul Mwite, if I remember, with vigor, and the court dealt with the question of opportunity. The court held, was there an opportunity for hearing to be given? And then 2, the reasonableness of that opportunity. But the court then went on to say that the court then must consider every case on its own merits, as the concept of fair hearing is an elastic one. Just to mention, my lord, the case of Onyango Law versus the County Assembly of Kisumu, which is an appeal that I argued and won, and that has been, heavy weather has been placed by learned friend, again, that's not you, learned friend Paul Mwite, on the Onyango Law case. My Lord, Onyango Law had not been served with any charges. This is just to distinguish the Onyango Law case. He was never served with any formal charges. My Lord, the motion for impeaching Onyango Law was presented in the County Assembly of Kisumu at 1 p.m. They then looked for him on phone and asked him to appear in the assembly at 3 p.m. He was not in any hostel. But my Lord, when he attempted to come to the assembly, he could not access the assembly. He was blocked by youth from accessing the assembly, not goons. So he was never heard at all. He had no opportunity, my Lord, to file any document before the assembly. He had no opportunity to appear by counsel. He was not present during the execution or the prosecution, my Lord, of the case against him as Speaker. And that is why the Court of Appeal set aside the impeachment, my Lord. Again, I successfully argued the appeal for Onyango Law. My Lord, given the time, I've exhausted my submissions before the court. As I had promised the court, my Lord, I'm fairly short, my Lord. Yes, my Lord, I'm fairly short. I am very particular about time, my Lord, and I thank you, my Lord.
Before you sit down, Professor, we have had substantive submissions on the issue of public participation. We have what Professor simply being respondents, when they make their opening statements, they start by saying that this is a peculiar case, had never taken place in Kenya, involved the impeachment of the deputy president, and therefore impressing upon the court to be very careful about. So tell me the case-by-case basis of public participation in this matter.
Yes, my Lord, my learned friend, Mr. Macharia, submitted that 200,000 Kenyans took part in giving views to questions raised by the National Assembly, and that the questionnaire that was submitted was lopsided, as it simply asked the public to tick against questions. One of our submission is that, again, the public participation, my Lord, should be viewed by the court against several decisions that have been made by this court, my Lord. I know several have been cited, my Lord, but against, my Lord, that an opportunity was afforded to Kenyans for 2 days to give views on the process. My Lord, the Constitution is slow. It does not say, of course, whilst public participation is a process and is donated by the Constitution, it does not say what the outcome or what threshold, my Lord, or whether once an opportunity is afforded to Kenyans to participate, that they must be compelled to all participate in that process. Because the question, and what the National Assembly Council has submitted on, is, was there an opportunity? Did the National Assembly provide through its portal physically and otherwise, an opportunity for members of this country or citizens of this country in various parts of the country to give views on the impeachment of Rigathi Gachagua? And I think the answer is yes. This court should therefore, my lord, not descend into the substance as to whether Njeri, the Women Rep Council, stopped participation in a particular polling station. Because obviously, my lords, there are individuals who did not support the impeachment of Rigathi Gachagua. There are those who supported. Members of DCP like Gachagua here did not support the impeachment.
No,
and therefore, you are not a member.
I am not a member of any political party because I represent them. There has to be a rule that a lawyer cannot represent. I thought Professor knew this.
My lord, members who represent political parties like Macharia then would not have taken part in the process. But my lord, the question then is, can the court then discern from documents filed before it that there was some process, my lord, that allowed public participation? My lord, the question of percentages should not be considered by the court. The Constitution and or statute do not provide for thresholds. So figures or mathematics, you cannot math legal processes and say it is 0%. Those percentages, my lord, in my view, are irrelevant. There was an opportunity to take part for the public to give views on the impeachment of the then Deputy President, Rigathi Gachagua. Thank you.
No, the workload we have tomorrow. How many of your council are remaining to submit?
My lord, I'll be submitting together with my colleague, Mrs. Mercy Plan. I think it's just two of us from the Senate.
From this end?
No, that is from the Senate. From this end,
yes.
My lord, I prayed earlier on for at least 2 hours. I will share it with my learned friend, Mr. Kenson Mutedia.
The Senate, how much time will you take the remaining members of the Senate?
my lord, I think between us we should be able to take just about 1.5 hours. I know my senior professor took most of the one from 4:30. We will try and make it a bit short, but at most 1.5 hours.
My Lord Prof tells me he's not a 1 hour man.
For us, my Lord, for the time to just maintain the 1 hour.
Dr. you take how much time?
2 hours, my Lord.
And you?
Well, I had indicated between me and my colleague will take just about 1.5. Maybe shorter because Professor has covered quite a bit of ground.
And who else? Who else? About 1 hour?
Yes, my Lord.
Who else? Do you have interested parties? Is there anybody?
I represent the second interested party.
So apart from you people, is there any other person who will be submitting tomorrow from either interested parties or respondents?
My Lord, that would mark the end of the respondent's case after the submissions by Dr. Kamado.
All right. So, my Lord, as we consider taking that time allocation,
yes.
I have not seen submissions by Mr. Kamodo's client, Mr. William Ruto. I have not seen the submissions.
It's for good. It's for good. No.
For the record, my Lord, we are not for the 6th respondent, we are for the 10th, the United Democratic Alliance. The 6th respondent is not represented as far as I'm aware. And for the 10th respondent, we have filed submissions.
So, rejoinder, how many people will be submitting? We are asking because we are pressed of time tomorrow.
We, speaking for the first petitioner, will be responding, I myself, Sharia, together with Mr. David Chill. We were going to take an hour between the two of us. I will add 15 minutes because my good friend, Professor Agenda, has mentioned to me more time for the number of charges.
Those who are friendly scores.
He's my good friend, he's my good friend. I need to return the scores as well.
But we are also going to take an hour on the issues in our agenda, but on account of the fact that we need to deal with the South African case, I believe I'll need an hour and a half. So that would be essential for fair determination of this matter.
My Lord, on behalf of the 44th to 49th, I'll also be making some rejoinder and now.
Your Lordship, on behalf of the 43rd respondent, 10 minutes.
If it may please you, my Lord and my Lady, on the part of the 50th petitioner, we'll just take 15 minutes.
My Lord, you may forgive me, maybe I've forgotten the nature of our legal system. Why would a rejoinder take an hour? A rejoinder is just an opportunity for you to address purely points of law that may require some little amplification. I don't know actually any court in the world, perhaps except here, where a rejoinder will take hours.
Yes, we are giving parties time to be heard.
I think,
but he's right.
Yes.
I was going to speak also on it. You know, we don't have a whole day. These proceedings cannot go on forever. Really, there's no reason why a rejoinder should take 1 hour. Honestly, in all fairness, there's absolutely no reason why a rejoinder would take 1 hour. Maybe, okay, let's go by some measurable parameter. If I ask in a council Paul Lute, how much time would you take for a rejoinder? Then you take cue from him.
We actually deliberately cut down the number of council to do the rejoinder. We have only 2. Maybe towards the end I may take half a minute, but it is substantively. The reply is substantively by Dudley Ochieng and Tom Macharia, in order to save on the court's time. And in that connection, may I also plead with the court to reconsider these 2 hours that Dr. Thionkulu, senior counsel, is talking about. Yes, he needs 2 hours.
My Lord, I'd explained why I need 2 hours. I don't think I need to repeat it in previous proceedings.
Okay, I think this is how we will proceed tomorrow. In as much as we have to accommodate parties, you will also have to understand that we have to bring the proceedings to an end. We have tried as much as possible to accommodate everybody. We will start off with the remainder of the Respondents' Council in the morning, and depending on how they will perform, we will make a decision as a court on the issue of rejoinder. We may give limited time for parties to make oral rejoinder, or we may consider directing parties to file rejoinder submissions. So let's see how it turns out in the morning tomorrow. Thank you.
We will go along with whatever directions that this court gives about the timelines tomorrow. Indeed, we do acknowledge from the bar that the bench has bent backwards over to accommodate all the parties.
Thank you. I think we'll adjourn. We'll meet tomorrow at 9.